and welcome to the debate. I'm your host Rafae Iqbal, and in today's episode, we'll be deliberating on some very important topics and developments that we're seeing in the country. In the first segment, we'll be talking about the need of the hour, which is politics of development instead of politics of agitation. As we move through Pakistan's political history and delve into it, we've witnessed long marches, allegations of corruption against the opposing parties. We've seen sit-ins in politics of agitation, and even today we see the same happening in the country. We have witnessed in the past as well that the losing candidates and parties level allegations of rigging against the other parties. And as we have seen in the recent past as well in the parliament, that the Sunni Ittihad Council members they leveled similar allegations against the ECP and the other parties as well. And in that regard, nationwide protests have also been called by the PTI on Sunday and the Sunni Ittihad Council members. If we talk about our second segment, that we'll be talking about the major Supreme Court's opinion that came on Zulfikar Ali Bhutto's case, the presidential reference that was forwarded to the Supreme Court. And of course, the Supreme Court in today's judgment gave its opinion on the trial that was commenced by the Lahore High Court, and of course the appeal that went to the Supreme Court of Pakistan. Of course, the court said that we can only give an opinion, we cannot undo what the previous judgment is. But of course, we'll be talking about both these topics in our today's episode. In the studios, we've been joined by esteemed analyst Farrukh Pitafi, and we have been joined along that by geopolitical analyst, very esteemed as well, Faisal. As guests, we have been joined by Barrister Shabbir Shah, who is an advocate of the Supreme Court, and Nouman Muhib Kakakhel, who is an advocate of the High Court. Thank you both for your time. I'd like to move towards our first segment to start off the conversation. When we talk about politics of development instead of politics of agitation, we see there's a lot of political polarization going on in the country, especially regarding the issue of reserved seats that we've seen in the past as well, in the recent past. And we've heard the speeches by the members of the Sunni Ittihad Council as well, such as Barrister Gohar and Ayub. I'd like to move towards Barrister Shabbir Shah for the first question. How do you see the ECP's judgment regarding the reserved seats playing out in Pakistan's political landscape?
And could you also speak about the possible remedies for PTI, because we have seen that Peshawar High Court seems to have actually given some relief today.
In my previous opinions, I have already, before the judgment, Farrukh Saab and Raja Saab would concur with me that this was a writing on wall because of a major flaw in giving the seats to the Sunni Ittihad. And let me just recap my opinion. And I maintain that previously it was unfortunate that PTI was deprived of its political symbol. That should not have happened. But because it has happened already, in the present case, there was no chance that Sunni Ittihad Council could have been allocated these seats. Now, why not? Because the law is very clear. The last date for submitting nomination papers was 24th of December. No nomination papers were submitted by individuals from Sunni Ittihad Council, and therefore the list now given by Sunni Ittihad Council could not have lawfully been given these seats. Another question arises, and to my surprise, a lot of people are saying that if not Sunni Ittihad, then why the other parties? I would, with respect, put forward my opinion that why not other parties? Because these reserved seats are seats for women. And then these reserved seats are seats for non-Muslims. I mean, I would, for one, not advocate that the number of women or the non-Muslims should be deprived of these seats. They would have to be proportionately distributed between other political parties. So the only legal recourse that Election Commission had available with it. Was this as unfortunate as it sounds, that PTI is deprived of those seats, but constitutionally and unfortunately that lost that battle from the Supreme Court? So if they have any claim, or that would be against the Supreme Court, not against the Election Commission in the present circumstances. That's my opinion number one. And Farrukh Saab, did you ask a question as well?
All right. I was talking about the possible remedies for PTI. PTI has been actually on one side agitating, on the other side it has also said that it is going to move courts. And now we saw that Peshawar High Court actually offered some remedy. It might be temporary, but there is some remedy that they asked Election Commission to stop issuing seats, reserved seats to other parties that might actually go to Sunni Ittihad Council. So do you see that there is any possibility of relief, or they are barking up the wrong tree?
And especially, Shabbir Shah Sahab, if we look at the relief, of course we know that Symbol, before losing it, PTI had some relief from Peshawar High Court previously as well. And then of course we saw that relief was actually negated in the Supreme Court. So this time around, do you think that Supreme Court would be, standing with the Peshawar High Court, or this time once more it would be the similar decision like the before?
And forum shopping again, is it going to become a thing?
Okay, so 2, 3 questions, very, very quickly. Previously, when the matter had gone to the Supreme Court, in respect of Symbol, I was of the opinion that the Supreme Court should have given them relief, because constitutionally they had a fantastic case. They should have been given their Symbol. But I was proved wrong and the Supreme Court held otherwise. Today, I am of the opinion that these reserved seats in the present circumstances cannot be given to PTI. And let's assume that but they have knocked the right forum. I mean, you can file a writ. You cannot deprive anyone to file or approach a constitutional forum. So assuming if the Peshawar High Court gives them relief, the ball will again be before the Supreme Court, and you might be surprised that the Supreme Court might correct its wrong, rather committing a second wrong, I would say.
Right, I'd also like to include Nouman, Muhib, Kakakhel, as we're talking about forum shopping. We've seen in the parliament that the Sunni Ittihad Council's Barrister Gohar, he addressed the issue to the Speaker of the National Assembly instead of signaling towards going to the courts. Do you think, considering regarding the reserved seats issue, the right forum is the parliament, or should the courts be burdened with political cases at the moment as well? And do you think there should be an appeal that should be filed in the Supreme Court regarding the reserved seats issue?
Kakakhel Sahab.
Are we audible to you?
We can't hear you. You'll have to unmute yourself.
I would be audible now.
Yeah, now we can hear.
Please go ahead.
Okay, so the case is obviously going to go to the Supreme Court because the Peshawar High Court have granted interim relief today with regard to the reserved seats. So when when a decision comes, whether it be in favor of Sunni Ittihad Council or against, they're probably going to, or surely going to opt for a CPLA to the Supreme Court, because they've preferred the same in all their cases. With regard to the opinion of the Supreme Court that political questions should not be brought before the Supreme Court and rather should be discussed in the parliament, I think the Constitution of Pakistan is based on trichotomy of powers, right? And there's the separation of powers as well. So when there's a wrong with regard to what's happening in the parliament, or in the executive branch of the parliament, when we say the ministries or the cabinet, then it is the Supreme Court that have to make right what have been wronged in the parliament. And when it comes to the issues of elections, then the law have given remedies to all the aggrieved parties to either opt for the election commission when the tribunals are not formulated. But now we have election tribunals. So those who are individually aggrieved of any balloting issues, rigging issues, they're going to go to the election tribunals, which have been formulated in different high courts of the country. With regard to the cases which are of public importance that we are discussing now, that of the reserved seats, they have opted for a constitutional remedy, and that is because it is not just one political party that is aggrieved, it is millions of voters that are aggrieved. It is the people who actually voted for the members of the Sunni Ittihad Council. They have brought them into power, they have brought them to the legislative assemblies. And as the constitution divides these seats between different political parties, then it is not being divided amongst the political parties, it is being divided amongst the people who have voted for them. Rather, they have been divided amongst the people who are registered voters of the constituency. So I believe it's not just a political question, it is a question of public importance. It is a question of well-being of the people in general that is to be decided by the courts, because the high courts and to some extent the Supreme Court, they are custodian of the fundamental rights as are provided for and protected by the Constitution. So they have to come into action and see if any fundamental right is being violated or stepped upon.
Yeah, no one, you have highlighted this, that of course, if we look at the members of parliament, they are actually aligned, and of course you have mentioned that they are basically from Sunni Ittihad Council. But on the papers, on the day of election, of course they were on the ballot paper as an independent candidate. In that case, do you believe that Supreme Court, while judging these cases, they will be looking into the facts available to them on the papers? They will be obviously going through on the ballot paper they were shown as independent. In that case, do you think that still Sunni Ittihad Council, I mean the same Sunni Ittihad Council did not give any sort of primary names that would be favored in coming in post-election scenario, coming as available for the female seats and women seats, and at the same time for the minority seats as well. At that time they did not mention any names, and though the constitution requires them to actually give the names, they did not give any names. Later on, of course, all of these independents, of course it's a political step of PTI to send all of them independents into Sunni Ittihad Council. In this context, do they still have a chance, because on the papers they were not associated with any of the political parties, do they have any chance of getting that?
Well, this is an extraordinary situation that we have before us, because when they filed their nomination papers, they were candidates of Pakistan Tehreek-e-Insaf. Later on, when they were stripped of their election symbol and they were forced to contest their elections as independent candidates, then they became independent candidates. First, they belonged to PTI, then they became independent candidates, and now they have been forced. I would not say they liked it or they wanted to join Sunni Ittihad Council, but they were pushed into that direction merely to protect the rights of the people who had voted for them, because they felt confident that they would secure a great majority. Now, if we look at it legally, what the law says, so I would say that no, they are not entitled to it. But if we look at how the whole scenario is, how the valuable rights of the people who voted for these people are involved, then we have to keep the law at aside and let sanity prevail, let equity prevail, let the rights of the people prevail who have voted for these people. So when we keep the law aside and when we let the rights, the fundamental constitutional and political rights of the people prevail, then I believe there is a way. Because when we go to the high courts under writ jurisdiction, that is extraordinary remedy, and we have to specifically write that there is no other remedy available to them, and we are asking for extraordinary relief from the court, then it clearly means that we are asking for something that is not provided for by the law. Because if it had been provided for by the law, if we could have a remedy by the law, then we would not go in writ jurisdiction initially, or we would not opt for it. But when we go for writ jurisdiction, when we say that our fundamental or legal rights have been infringed and we want a writ to be issued, then it is a special circumstance and it needs to be visited, rather decided in such a way that rights of the people in general and the public at large are saved. So there are two situations, and the courts have to decide whether they have to stick to the law in strict sense, or they have to look at the rights of the people and protect them.
Right, Farrukh, I'll also like your comment, because as far as we're seeing the conversation, it seems like it's a matter of statutory laws versus moral ethos. What's your comment?
Right, and Rafae, of course, I don't have any personal opinion on the matter. I strive to go by the law, and my very humble submission is that whether you agree with the Election Commission of Pakistan's judgments, verdicts, or not, one thing we have seen regarding that symbol case earlier, that when they actually built their case, they did not leave behind any loophole for the law to exploit and give some kind of relief. For example, they actually went to the idea of constitution of a party, and then they quoted PTI's own constitution and their own standards set by their own constitution, that whether you are meeting those standards or not regarding their eligibility in the election, right? And especially their transparency of their internal election. So what happened in the end? In the end, what we saw was that the same matter went to the Supreme Court, and anybody who kept on watching the live streamed procedure, you could have could have seen that there was hardly any possibility that the court that is going by the book will find any kind of escape from those arguments that were there. So this time also, my humble submission is, it is an emotive matter, because whenever PTI is there, and if you are somehow aligned with its perspective, then naturally you are going to be very emotive, very aggressive regarding this. But I think that here too, ball was primarily dropped by PTI when it became very clear, and I remember Kakakhel Sahab and Barrister Shabbir and Raja Faisal actually were interacting with me in the very same program, and repeatedly at that time it was clear that they are not going to get their symbol. So they had to have a plan B. For example, choose, today you're talking about forum shopping. You could have actually said that this party has potential. Let us do one thing. Let us ask the head of this party, not PTI, something else like SIC, that you submit our identical list of candidates for women and minorities. That could have been very easy cheat out of the whole situation, but that did not happen. They did not actually plan ahead, and that's why now we are in this situation. Now the whole idea of people of Pakistan somehow getting their right, or that right being denied, I think that when it comes to the courts have to essentially look at two or three things. One, of course, PTI has actually brought up an earlier precedent, and that was Bap Party's precedent. But apart from that, as ECP actually said, that they did not produce any evidence regarding that. But my point is that no matter what, if Bap decision was correct, right, that is another thing. But ECP or Supreme Court can say that decision was not correct. Remember that in the end, these seats are reserved seats. They are going to go to women and minorities, and they will go to women and minorities no matter which party actually does it. Now the problem is that at this moment, two entities, first PTI and then SIC also, both are not being considered legitimate actors in the parliament. One lost their symbol, the other one did not, and by its own admission, that letter that was presented by Election Commission citing the SIC's head, that we did not contest any elections, so how can we produce any list of women and minorities? That will create problem for them, and they won't be able to find a remedy, I think. But that doesn't mean that these seats should be left vacant. They have to be reallotted, so they will be. Now regarding agitation that you were talking about, The simple fact is that at this moment PTI has decided to agitate and take it up a notch, because earlier it was a hung parliament, and in a hung parliament there is always a possibility that when you need 2/3 majority, you are going to go to PTI and ask them to help them. And they could actually extract some kind of concessions. It has been happening in the past. But this time now, after these seats being reallocated to other political parties, the current majority of the ruling coalition becomes 2/3 of the majority.
Yes.
So that becomes a problem. But my humble summation is that PTI has to eventually realize that it is not the number game that is going to provide them relief. It is the patience game. You'll have to actually wait it out, and this is the biggest problem. PTI does not seem to believe in patience. It has been actually struggling with the system since it was put out of the government, and because of that they have actually maneuvered themselves into a corner out of which they find very difficult to get out of it, right? So, but eventually they will have to, and only patience will help. Their governance and politics of development has helped them in Khyber Pakhtunkhwa, elsewhere as well, health card and all.
Yes.
If they actually focus on that, and this government that is created, instead of focusing on agitation, keeps on working on good governance, eventually it is going to be their argument in their favor.
Right, Farrukh, just like PTI mentions cricket puns with their politics, I'd like to say that this is politics should be considered as a test match, not as a T20. Staying on what Farrukh just added, I'd like to ask Shabbir Shah, considering SIC's letter, the Sunni Ittihad Council's letter to the ECP earlier that was presented in the ECP, can the SIC have a change of heart like that, and how will that be holding up in court?
You see, SIC's letter is one thing that does not prevent, in our legal language, we say that there is no estoppel to the law. So even if a right of a party is made out just because you have made an error, would not in itself be a fundamental block, in my opinion, to them. But like I pointed out, their wings, they had no case the moment they missed out the deadline. It is very important. Every party gives their list, and as per their list, those individuals have to submit a nomination paper. They have to appear before the RO, and the returning officer can say that, all right, well, you are not qualified, you are maybe a foreign citizen. So that scrutiny of SIC's individuals has not taken place even till today. That is the point. So, I mean, if the list of the SIC contains individuals who are foreign citizens, who are not qualified, who are not of age as yet, who are convicted, how do we know? They have not gone through the scrutiny of the nomination papers. So that is their fundamental difficulty.
Right, Raja Faisal, I'd also like your views, considering that we're talking about the whole crux of our conversation is revolving about statutory laws versus moral ethos. The PTI and the Sunni Ittihad Council members are arguing that it is morally wrong that they are not being allotted the reserve seats. On the other hand, we see that the law and constitution says otherwise.
Yeah, Rafae, obviously, if I talk, I'll be very honest today about, I'm a law dropout. In the second year, I left law. Okay. But of course, when somebody asked me a question about constitution and law, I always try to figure out the right way to answer it. And being a student of politics, international relations, and defense and strategy, what I have learned so far is that for any country, democracy is key. And when it comes to democracy, of course, the basic principles should be followed, and the basic principle for any democracy is that the will of the people is assessed in an election. Throughout Pakistan, will of the people is assessed, and of course, what is the job of ECP is to assess the will, what people want. Now they have assessed, and they are in the best position to know what people want, people of Pakistan want. So on that basis, I would say that this particular case, in this case, I would agree with Nouman Kakakhel when he said that, of course, it's the will of the people that should have been respected. And I think prima facie, the things are apparent that the will of the people was requiring a decision, and that decision, of course, should have been with the ethos should be looked after, because here will of the people and the basic principles should be followed, because we should not be forgetting that the very constitution we are highlighting again and again, that constitution is a product of the will of the people, because will of the people comes on the constitution avenue, and that constitution avenue actually designs the constitution itself, which is being followed.
Designed. That was one-time affair.
Yeah.
Now Constitution has actually taken shape.
Taken
now you
shape.
can amend it,
Taken shape.
but whatever it is, you cannot wish it away.
Taken shape, but still, will of the people is supreme when it comes to even anything, any law when it gets discussed.
Raja Sahab, whose will? Who's going to decide whose will it is? Is it going to be you or I or institutions?
ECP. ECP will decide.
ECP
and of course,
has to
ECP
balance law and procedure, and then of course mandate as well, right? It can't be only just focus on whatever I want you to focus on and leave the two other things behind.
What I believe in this in this specific case, how I see it, of course, giving all of the seat to the other parties, this doesn't make sense at all, because
so what should be done?
What should be done? Respected. The will of the people should be respected.
But if you cannot
will of the people, if will of the people is respected,
hang on.
then of course these seats should be
If you cannot allocate these seats to PTI for that matter or SIC, what should you do? Keep it vacant?
No, not vacant at all. Not vacant at all. But law should take its course, and on the basis of ethos should be followed, the basic principles should be followed, because these kind of situations, they have never taken place in Pakistan's history. When there is a case that has no precedent at all, then of course you create a precedent, and I think the precedent which is being created, this has some kind of basic principle problems.
Right. It's nostalgic because it reminds me of Darwin and Hart's debates, that focused also on morality and the statute. Nouman, Muhib, Kakakhel, your views on what Farrukh Pitafi and Raja Faisal just had to say.
And what Barrister Shabbir also had.
Yeah.
Do I have to... What's it said? I think I agree with that, but see, if we focus on the will of the people, sir asked a question whether which person's will do we follow? So it's a very simple answer to that. We have to follow will of the majority, the people who have gained majority through votes. If a person has been elected in a certain constituency by the people, the voters of that very place, then the person who won that election, he is will of the people. He is to decide what's best for the people. And when we said that these are reserved seats and it is to go to the women and the minority, these are reserved seats for women and minority, but these are also voters in the Legislative Assembly. So the will of the people through women and these minority people who are to be sent to the Legislative Assembly are to be taken there through the people, through will of the people who have elected their representative. They have to select which women and which people from the minority have to sit in the parliament, sit in the provincial assemblies, and they have to support the stance of that very political party. Now, when we say that it can be anyone from any political party, as far as a woman is sitting there or a person from minority sitting there, it's not as simple as that. Because that very person is also a voter in the parliament, is a voter in the provincial assembly as well. He have to vote on, he have an equal vote on every bill that is to be presented. He have an equal say as an elected representative of the people. So I think it is very important that people are brought into power. They have been given they've been given the authority by the constitution to choose a person on the reserved seats through their very political parties. So if you take out political parties who have taken majority of the votes, it will be a very futile exercise to take those people and make them sit in the legislative assembly, because they no longer enjoy the strength that they get from the votes of the people while they sit in the legislative assemblies. You see, when we talk about legislative assemblies, the support of the people is very important. But when we talk about democracy, it's important that a person who's sitting in the assembly is always and always supported by the people who voted for them. When they lose their confidence in that very person, that is the very moment where he loses his legitimacy. So he is to be supported by the people who have voted for him throughout the tenure that he's going to spend there. So when I say that a person who is sitting there, and when Sir said that will of the people is to be respected, it is by the constitution in the very preamble and in the very first constituent document that we call the objectives resolution and the speeches of Qaid Azam. When we go back in history, it have times and again been brought into the attention of the people, rather propagated, talked about, debated upon, that will of the people is to be supreme. It is to be followed in the guidelines of Islam, but the will of the people is to be taken in consideration of everything, whether it is a domestic law, any legislation. Only the constitution is to be held supreme. But even in the constitution, in the recent judgments, if we see the recent judgments, they say that even if the provisions of the constitution are violative of the fundamental rights, even that loses its legal and constituent value. So will the people is to prevail over
Absolutely.
any amendment or any other.
Kakakhel, nobody is saying that will of people should not prevail. The only problem that we are actually focusing at right now is technical issues and how laws were created. My humble submission earlier also, that day when last time we were debating the symbol issue, I again said that there has to be some kind of a legal or constitutional remedy within constitution, especially ensured by the framers or the amendments per se, to ensure that these things don't happen, these dead ends don't come up again and again, and we kept on hitting walls. But my humble submission is that essentially it is an affirmative action. You don't actually directly elect people to these seats. These are actually indirect appointees who actually go to these seats. And if election commission does not find one participant competent enough because they have missed the procedure, you cannot actually just say that this is the will or this is the will and just wish away the procedure. Then it is basically an allotment of these seats is essentially an arithmetic game, that whosoever is a legitimate actor within the parliament, they get this number of seats, and independents don't get those seats. But of course, I was hoping that perhaps then they could have actually said that okay, every province gets by their own population size, they get their MPAs or their MNAs get to choose or nominate 2 people or 3 people. But these things are not written into the constitution. Should ECP or for that matter any court in the country create law, they should actually decide on their own that there is no such precedent, and we have to actually, we are looking at these situations and we actually decree that today this is going to be the new law. That is something that we have been debating against repeatedly in the past. Remember what happened with Iftikhar Chaudhary. Remember what kept on happening with the other courts as well. So with that kind of a situation, it becomes troublesome that we are asking courts or election commission to actually punch above their weight or go beyond their own mandate to respect what you are calling people's mandate, because they are not essentially qualified or equipped to take care of the matters only of the mandate itself, sans constitution.
Right, very rightly put, and of course, these are times that these are questions for the executive and the judiciary to ponder on. And since we're discussing judicial verdicts, we'll also be talking about our second segment today, which covers how the Supreme Court wrapped up the Bhutto's reference, which was a reference sent by the president. If we go to the backdrop and the background of the case for the understanding of our viewers. July 5th, 1977, Prime Minister Zulfikar Ali Bhutto was ousted. The same year, he was arrested on accusation of being behind the killing of critic Muhammad Ahmad Khan Kasuri. 1978, Bhutto was declared guilty by the Lahore High Court. In 79, Bhutto's appeal in the Supreme Court was dismissed with a 4-3 verdict. 1979, the same year, Ziaul Haq upholds the death sentence of Bhutto. In 79, Bhutto was hanged at the Central Jail in Rawalpindi. Bhutto's son-in-law and Pakistan's former president Asif Ali Zardari had filed a reference challenging the trial. In 2011 then, we saw the Supreme Court taking up Zardari's reference. In 2012, the hearing of the reference was adjourned. In 2022 now, we saw a 9-member Supreme Court bench was set to hear the plea against the Bhutto trial, and today the Supreme Court gave its opinion regarding that trial. Barrister Shabbir Shah Sahab, I'd like your learned views on the Supreme Court's opinion today.
Thank you. Before the Supreme Court, I wanted to express my opinion on Raja Saab. Raja Saab, I like the new Raja Saab, how his conscience has just suddenly woken up, and he's talking about the will of the people. When PTI was deprived of its symbol, the will of the people was not commented upon. And even before, when there was pre-poll rigging, Raja Saab stayed silently and did not agitate as much. So today, I mean, I like the new Raja Saab. Please, he should stay the same way, because it is better that we should have a difference of opinion, and we should have someone who at least now follows the law and the constitution.
I would like you to know that he keeps on agitating, but not on screen, before us. And he takes it out on us, nobody else. Yeah.
May I with respect say that, sir, because you overpower him. Your personality is very overwhelming. So when you are around, then it is difficult to disagree with you.
But go ahead, sir.
But thank you for the question. Let me go back to this very, very serious question. You see, it is a historic day for Pakistan. Why do I say that? Is because, one, the Supreme Court, it was not just that a military dictator had staged this, but nothing short of the Supreme Court of back then, which was itself created by the constitution, which was given to this country by Zulfikar Ali Bhutto, exercising powers under the same constitution. The Supreme Court had approved, and what is now referred to as a judicial murder, because you see, today the Supreme Court has approved of that. And when the reasons come, you will see that such mistakes were made which are elementary principles of criminal law. Not even a first-year student will make those mistakes. Now, allow me, because you don't have the reasons as yet, allow me to shed light on 3 or 4 fundamental defects of the trial court as well as the Supreme Court back then, very, very quickly. As you've pointed out, that it was a split judgment of 4-3. The 3 honorable judges who had acquitted Bhutto Saab in the Supreme Court, and the leading opinion was Justice Dorab Patel's opinion. I urge you to read that opinion and also to publicize it and also to telecast it. It is a fantastic read because it sheds light. It destroys the other side's evidence. Number one, what it says is, and it was alarming for me, that how is it that the other learned judges of the Supreme Court stayed quiet even after this was highlighted in the learned judge's opinion? And what did he say? If I have time, should I shed light on this?
Yes, please do.
And you know, what did he say? He says, sitting in the Supreme Court, that Mr. Kasuri has first filed an FIR alleging that Mr. Bhutto has murdered his father. After filing the FIR, he has been, through intelligence reports, reliance is placed on intelligence reports that Mr. Kasuri has been desperate to seek right of audience from Mr. Bhutto and eventually wanted to join Pakistan People's Party and ended up joining Pakistan People's Party. So the judge records his astonishment that how is it that somebody who yesterday thought that this is a man who's committed murder and today is desperate to meet him and join his political party. So he shatters his evidence. And the other evidence was that two star witnesses of the prosecution who had confessed before the trial court that we had given this confession under coercion. Their evidence was relied in the High Court later on. Third fundamental flaw was that the approvers, any practitioner of criminal law would tell you that the approvers' evidence, unless corroborated by independent evidence, is of no value in the eyes of law. Now, this, if you show to a first-year law student, they will tell you that this is a no case. But the Supreme Court endorsing that, yes, we are sentencing Mr. Bhutto to, they were convicting him. Now, this is shocking. And you know what is shocking for me the most is the same judges, including Justice Dorab Patel, and not many people know that, and the other learned three judges, when a review petition is filed, all the three dismiss the review petition. Now, this is an irony of justice that the three judges are saying that there is no chance of conviction. They are acquitting Bhutto Sahab with such conviction. Later, they dismiss the review. So this was the state of martial law. This was the state we were in. And thank you, Supreme Court, today, that notwithstanding the fact that they had limited jurisdiction because they were exercising a jurisdiction under Article 186, which was that a reference was sent. They have today made a historic judgment and they have corrected their own wrong because you see, history doesn't forgive anyone. History sets the record straight. That is why it is a good day for Pakistan.
Barrister Shabbir, very quickly, I wanted you to actually comment also on this habit of ours to comment on the judges that have passed and who have actually made decisions that might at this moment look unfair. But at that time, again, they are only mortals and there was a dictator sitting and there was so much pressure. I asked this because you mentioned Dorab Patel, one of the finest judges.
Yeah.
My question is that is it fair to judge them in this light? Because every time PCO actually there is military takeover and then there is PCO, people said that they should have quit, they should have not taken oath and not gone with the system. If they wouldn't have, somebody else would have been there in their place. So how can we actually have this luxury of judging them because they are mortals and they are equally vulnerable as you and I? They don't have any tanks, they don't have any guns to protect them.
Let me thank you for asking such a brilliant question. I am not in two minds. If they are mortals, they don't have the license to kill someone. The least that they should do is to resign. I mean, if you are mortals, you have a pressure from military establishment, let me call them. So what should you do? You should hang someone? I mean, it is the least that they should do is that they should resign so that today what the history is doing them and their sons, their daughters would have to face embarrassment. And I have sympathy, but the point is that why did they? Who was forcing them? It was not as if they would have been murdered, and even if they were forcing it, that the least they could have done they would have resigned.
It kind of reminds me of one edict actually attributed to Imam Abu Hanifa, that if a woman is asked to marry someone upon pain of death, if she actually decides to concede to marry, then it is a legitimate marriage because she had a choice, either to die or then to marry.
Right, that's a very interesting example. Nouman, Kakakhel, what's your views on what Shabbir Shah Saab just had to say?
I think everybody would agree with Sabir Shah Saab's opinion on this. Nobody can disagree with this. Whenever we join law school, the first thing that we discuss, criticize and destructively criticizes the judgment that has been passed in the case of Zulfikar Ali Bhutto, because it has been made, a mockery of the law has been made, and has asked whether these judges were forced or whether they were coerced into it. These judges have the responsibility to create a balance in the system. They have the responsibility to protect the people from martial law administrators, or whether somebody tries to usurp power over any other person, because they are there for keeping a balance with regard to the checks and balances system. But they did otherwise. Instead of protecting the people, the constitution, the then prime minister, rather the former prime minister, they opted to protect their jobs, their salaries. That is what they did, and they will forever be criticized for that. Now, with regard to the judgment that has been passed by the Supreme Court, how I see it, it's a public apology by the Supreme
Right, we're having audio trouble with Nouman Kakakhel.
Court. 11, if the limited time, uh, yeah, am I audible now? So I consider this to be a public apology regard to the past sins that the judges of the same court had committed by hanging a premium who was supported and a very popular leader of the country by that time. They will give reasons like, if you go through the opinion, it's a very short opinion that have been given by the Supreme Court. They say that we cannot undo what we have done. We cannot reappraise the evidence. We cannot undo the sentence that had been given, but we will be giving reasons as to how it was unconstitutional, as to how it was illegal, as to how the due process was stepped upon, and a fair trial was not given to Zulfikar Ali Bhutto, and all the illegalities that are connected with it. So, how I see it, it's an apology by the institution on an institutional level against the whole public, against the subjects of the country who live under the Constitution of Pakistan, that they were all wronged by the Supreme Court in 1979. Firstly, when the appeal was decided. Secondly, when the review was filed and it was dismissed, and he was finally sentenced in lieu of that very judgments of the Supreme Court. So we will see the reasons, and all these reasons would then again indicate that an apology has been bench of the Supreme Court. So I think it would be an example for the judges to come, that they would not commit the same mistake again, and take the confidence from the people that they enjoy in the Constitution, in the law, because if they cannot protect the prime minister of the country or any other leader, how can a layman or an ordinary person expect justice from the same system where the prime minister is being hanged merely because he is not enjoying the support of the martial law? Like Sir Shabbir said, it was a judicial murder, and it will be forever labeled as a judicial murder.
Faisal,
just the one liner on this case. I would agree with both of them, and at the same time I would just want to add in that on that day when, of course, it was decided to hang Bhutto Saab, I mean, Bhutto was dream of 110 million Pakistanis that day. He was hope of 110 million Pakistanis that day. It was not only Bhutto who was judicially murdered, it was hope and dreams of more than 110 million people, Pakistani people. It was their hopes and dreams that were shattered there.
Right. Very quickly, Rafae,
yes,
I just want to point out what happened in '79 is something else. And of course, I'm glad that Supreme Court of Pakistan has actually answered those questions or tried to do that. My biggest question for today's bench is not that what happened in '79, is it a concern or not? The fact that it took this reference 12 years to come to a conclusion, that is a bigger question to answer. Because these are the judges who were around at that time also. And you have to actually ask yourself, why is it that for one president sends a reference, then he is goes out of office, and now he is returning. And at that time, after 12 years, you are offering this relief. It could have been granted earlier. Why is it that it takes our honorable courts this much time now to give this kind of relief?
Yeah.
Right, with that, unfortunately, we're short on time, but of course, today we deliberated on some very important aspects of the democratic and judicial system of Pakistan. Regarding the first segment, the need of the hour, politics of development instead of agitation, democracy, patience for the PTI and Sunni Ittihad Council is what is suggested, and of course progressive politics and dialogue is what they should have their aim for if they want to, if they seek a reconciliation. Regarding the Supreme Court's opinion on the Zulfikar Ali Bhutto case, the reference, we had the analysis from esteemed Shabbir Shah Sahab and Nouman Kakakhel Sahab. Along with that, Farrukh, Pitafi and Raja Faisal also contributed. It's a very welcome step. As they say, better late than never. The Supreme Court has tried and did try to correct the mistake that it had done in the past regarding the trial of Zulfikar Ali Bhutto. With that, we'll conclude today's episode, and we'll meet you same time tomorrow with a new set of topics, and we'll be having the same insights from our analysts and the set of guests that we have. With that, we conclude today's episode. Till then, stay tuned.